together. And over the years, we've had a director of enforcement, several SEC staff before, but Joe is a little bit different. Joe has handled over 1,500 criminal cases against some of the worst characters in the world. I went upstairs to my room and looked at the pacer, and I saw that there were 1,200 entries with Joe's name on it, all out of Southern California. And I was a little concerned that he put some of my clients. Sure enough, he put one of my clients in prison, so we're going to get an opportunity to talk about that at some point. Joe will also talk to you a little bit about how to handle a subpoena when it comes in, and not to just flop around the dock like a fish before you start to deal with the issue. Mark is going to discuss some of the exchange rules that have been affecting us, and then Morris is also going to talk about some comments, firing, reporting, some of the things that are on the forefront of our industry. The Securities Enforcement Manual is brand new. It's the first iteration that we've had since 2017 of the Enforcement Manual, and there are enormous changes at the SEC. There are very few cases being brought right. In the second half of the year, there were only 5 cases against public companies, and 3 in the last half. It's down from 53 cases last year, and there have been 3 dismissals since the Trump administration has come. Mark, talk to us a little bit about the exchange rules, because that's in the paper today.
Yeah, so thank you. My name is Marc Indeglia. I am a partner in the co-chair of the corporate department at Lahiji. We're about a 100-person law firm here in Southern California, and we've been around since 1988. My partner Joe is here with me. Yeah, so it's interesting, Todd. One of the mantras that you're hearing from Commissioner Atkins, who is the new chairman of the SEC, is he wants to make IPOs great again. And that all sounds great. And, they just had an announcement recently that they're going to start to try to price the SpaceX IPO, which everybody's very excited about, which is, I think the second big IPO that's been out in the media this year. But overall, the concept of making the IPO great again was that we would have more IPOs of companies all across the economic spectrum. And the reality is that at the ground level, the actual opposite is occurring. And for those who are in the industry that are small or micro-cap companies listed on one of the major exchanges, there have been a lot of rule changes, some of which have gone into effect, some of which have not or are pending, all of which are making it more difficult to be a public company, to become one, or to stay one. If you look at the trend over the past year and a half or 2 years, every rule change that is coming out of NASDAQ or the New York Stock Exchange when it comes to smaller public companies or smaller reporting companies is they're making it more restrictive, they're making it more difficult to stay listed, and it's become a very big concern in the industry. And to the point where the last rule change that was of big significance that was proposed was that NASDAQ proposed a rule where if you traded below $5 million market cap for 30 days, you were automatically delisted from NASDAQ with no opportunity to appeal. You go right down to the OTC markets, which at one point in my career was not such a bad place to be. You could still operate and raise capital, but it's become much more challenging over the last 10, 15 years to raise any capital, have any real investor awareness, maintain a shareholder base. And so a lot of companies are definitely afraid of being subject to this $5 million rule. And it's not just going to affect companies with $5 million market caps, it's going to affect companies with $10 million market caps and $15 million and $20 million where they're one short squeeze away from being below $5 million for days. It actually creates, in our view, a very perverse incentive for people to go out and try to short companies that are hovering in that area, because if you can bang them down below $5 million and keep them there and they get delisted automatically, you just made $25 million or $20 million or however much you put out on the short, because they're never coming back. The probability is very low.
That sounds like an exciting opportunity also.
It is. So for you short sellers out there, we just gave you an arbitrage.
Mark, you're the chairman of the SPCC?
President, yeah.
The president of the SPCC.
Yes, Small Public Company Coalition.
What is the Small Public Company Coalition doing to lobby our government to make changes?
Well, so our organization is called Small Public Company Coalition. It's something that I do on really on a volunteer basis for this community of people in the small and micro cap space, where we advocate for issuers and investors and bankers who are in this industry on issues that are important. Many years ago, we opposed the 144 amendment that they had proposed. There was a whole bunch of litigation against PIPE funds and ELOC funds and other funds that they were being charged to unlawful dealers or unregistered dealers. And so we've been fighting those cases for several years. And now we are very actively opposing, I think, 3 NASDAQ and 2 NYSE rules that are all designed for smaller public companies. There's a 25-cent rule that NASDAQ, that New York Stock Exchange tried to put in play, proposing that. So we've submitted comment letters with economic analysis by former SEC economists to explain that 78% of the companies that have fallen below 5 million over the last several decades have all recouped and gone on to do great things. There's one that, that ended up being a $2 billion company after it had been falling below the 5 million mark at one point. We actually tomorrow, interestingly enough, have a group of CEOs and some advisors and a couple of my colleagues in the legal industry are going to be meeting with senators and congressmen tomorrow to see if they can put some influence or, at least voice their opposition to these rule changes, because we really do think it's going to harm small businesses, smaller public companies. It's going to impede innovation. It's going to cost people jobs. There's a lot of real economic effect that's going to happen if these rules continue to go into effect. The regret that I have is there's one rule change that some people are aware of, where NASDAQ has now said that even if you meet all their listing standards, they have the right to discretionarily deny your application. So you can meet every MARC objective standard: income, market capitalization, shareholders, stock price, amount you're going to raise in your IPO, and they can still come back and say no. And the stories we're hearing are horror stories, that there's very little transparency in the process, and it's very somewhat authoritarian.
So it's going to put a real chill on companies choosing to do that gauntlet.
Well, I think it's very difficult for me to understand how we're making IPOs great again when we're having companies that are otherwise qualified to become publicly traded companies and do a successful IPO with a quality banker for a reasonable amount of capital, and then at the very last second pull the rug on them and say, no, you're not going to be able to list on our exchange, which is sort of a key point of going public.
So you're dealing with filings on a daily basis on comments that are coming back from the SEC. I'd like you to touch on the comments that you're receiving and whether or not the policy things we're seeing in the paper and in daily releases from the SEC are boiling out comments. And then if you could follow up on that with how you feel about this push for reducing the reporting requirements by half. Biannual report. And if you could direct your commentary in that direction.
Not for my clients. Only because I work on a flat fee basis. They generally get all of it included in their monthly subscription amount. It's actually less work for me if they don't, but I can go into my opinion about that strategy. So in terms of what I'm seeing in comment letters, like you said before, enforcement has gone down significantly over the last 6 to 12 months. I feel like that kind of trickles down into the comment letter arena. What I've seen kind of goes into a few different buckets. One's silly mistakes.
Your silly mistakes?
Not my silly mistakes. I have a very good record of getting completely no reviews for every single one. It happens every so often. So silly mistakes by the drafters, they don't include X, Y, and Z into the thing. They get 10 comments on things that absolutely don't matter from an SEC perspective, but that they have to bring to the attention of the drafter, which is fine. I think this also goes to something that we were talking about earlier, which also leads to other problems, which new SEC staff members, right? So we have SEC staff members 2 years ago that knew what to look for and focused on specific issues that the SEC were really focusing on, versus recent staff members that may be doing a full rule check against your file S1. And I have seen comments for some kind of crazy things that I've never really seen before lately, because they put a lot of responsibility on the younger staff members to catch as many things as possible. So that's one bucket. The other bucket, which I think kind of goes to your point of what is in the atmosphere of headlines, is ties to China. It's a big focus for the SEC. If you mention China if anybody in your management team or directors have a tie to China, you're a SPAC looking for a target that you may be open to a target in China, you're going to get comments on that, what your disclosure says, what impact that has on your future shareholders, and how heavy those ties are. And then, there are a couple of other buckets in there that is the bulk of what I've been seeing. The staff members doing this rule check that associates do at the law firm, on the law firm side, they really do catch almost everything that are missed. Silly things like, not putting in a termination date, which technically don't really need, but they have been commenting on the way that had to deal with it. I was on the investment banking side and didn't get into the S1 on the other side. Not putting the right formatting for exhibit tables, not putting in material contracts that have been filed in the past, not putting in your callback policy and your 10Qs and Ks. So you'll get comments on those, especially at the microcap level. They're really scrutinizing. Back to Mark's point of, where does this make IPOs great again? For me, I think they're really kind of focusing on the bulge bracket IPOs, right? It's a marketing thing. If the administration can say they had the biggest IPO of all time, that's the win. Like we were talking about before, you get SpaceX IPO behind that, Anthropic behind that, the other OpenAI. They have a nice run of really large IPOs that they can point to and say, look, IPO is great again. So we had a conversation once early in our relationship time where you said something that stuck with me, which was the IPO market was not made for these large companies that are just have investors looking for liquidation exit. They're made for microcap companies looking to grow and expand and create a product and innovate, right? So, that kind of goes to the antithesis of what the IPO market and capital markets were made for, and which is a little sad for me. And to your last question, the semi-annual, biannual, whatever you're gonna call it. So, I think it's gonna end up being a voluntary disclosure. My personal opinion, from a shareholder investor perspective, I think shareholders and investors go to expect the companies that have already been doing their quarterly reports to continue doing them, especially at the microcap level, right? We have a communication problem, right? We have a lot of IR and PR firms out there that really try to solve it, and a lot of them are here and they're phenomenal. But, to cut that butt from the yearly reports to investors that they can see and tangibly point to and say, hey, look, this is how they did over the last quarter. To cut that in half seems kind of counterintuitive to the microcap communications to shareholders.
I think it'll be really company-centric. Some companies have less volatile financials, or they have like a cleaner run of their financials.
Last year, at the SEC, every year the SEC has a small business forum that they hold at D.C., and I went last year. This topic actually came up and was raised by a CFO, and this CFO had originally been with a foreign private issuer, which, for those who don't know, if you're a foreign private issuer, you only have to report semi-annually. And she had worked for that company for a number of years, and then she took another job with a company that done an IPO under the standard U.S. reporting system. And I have never heard a CFO complain more loudly than she did to the SEC about having to, and it was, she said how much time it took away from doing other things other than, just getting the quarterly reports out every 90 days. And I think there was a lot of that sentiment that came out in the first, call it year of the commission soliciting feedback on how to make capital markets more easy for smaller companies. And I think that's really where, I don't know if I'm not saying it came from her, I just remember that presentation and of course, having represented some of these foreign private issues, it does reduce your cost and, less, you have a client Morse's, but, even so with the audit, the real fees are in the audit review. And that will get cut back, so for those who are at the accounting, a little bit of cutback. But ultimately, I think what you're gonna see is you're gonna have a number of folks and a number of companies test this out. And if they do not take a big, 15, 20%, 30% liquidity hit because they're not reporting them and keep doing it, you're gonna see it grow. I think if you see a big liquidity hit in their marketplace, is when people are going to say, okay, that's not going to work for us.
Right. I think that's exactly it. I think the investors are going to be the ones, and shareholders are going to be the ones to tell us if this works for them or not. That's a good point. I think that the lower disclosure threshold is a good thing.
In fairness to the commission, I will say this: they have come up with some things that have been very helpful for smaller companies. We've always taken it for granted, but the whole ESG movement and the climate disclosure rules that got killed, that stuff does matter, because the scope of what you were going to have to do with the climate disclosure rules, nobody really appreciated just how expensive that was going to be for companies. And they are talking about liberalizing the S3 rules and the F3 rules to allow for bigger shelves rather than, if you have a market cap of $30 million, all that's float, then you're limited to $10 million on a shelf, which, companies can go through very quickly, especially if, you're constantly accessing capital markets. They are talking about loosening those rules. In a way, I would encourage them to do so, because I think having shelf capability is very important, especially when you have stocks with a lot of volatility. So I do think they are doing certain things in certain areas, but there's got to be a better coordinated concept. I understand, that the exchanges, do want to maintain their reputation as quality places for quality companies. But I think what you're seeing here is a huge overreaction to some negative situations that occurred last year. That hopefully reason will come and you'll have rules that help.
Well, that's a good segue into discussing the enforcement manual and the changes to the enforcement manual.
Today's big news. Today's big news.
And today's news that they accepted the SEC's rule on
denials.
Oh, that's right. So, Joe, when I met you yesterday, one of the things that I've been following securities fraud since I was a cold caller. It's something that keeps me particularly interested. I'll read SEC releases at 3 o'clock in the morning. Something really interesting. One of the things that I've noticed over the last 30 years of reading securities fraud enforcement is that San Diego seems like it's a special place. It's one of the only places, not in Boca, not in Vancouver, you don't see it in Nassau County, Long Island. In San Diego, they run sting operations. They have securities enforcement FBI guys that act like jump out boys doing buy and busts, like the wire.
I have to say that they're never in Wichita or Minneapolis or
No.
places that are cold, like Fargo.
But they're also not in Boca Raton, which is where
Hotel rooms are very expensive there.
they're expensive.
Tell you as a prosecutor, it's so hard for me to sit down and do this the entire time. I've
It is,
probably
what it takes.
shifted like 4 times in my seat because I just want to stand. It's absolutely unique to San Diego because our prosecutors in San Diego are trained so early on in many different enforcement tools that are available to us. You think about, I was a white collar prosecutor when I was in San Diego, but we're trained so early on to use all of the tools that are available to even like cartels. And so things like wiretaps and using undercover cooperating witnesses and undercover agents to do sting operations for white collar cases is very unique. But it's because we were trained to think like that out of the box as prosecutors. And so we use those tools, and the FBI loves it because here we are being aggressive in a space where they're not used to being aggressive in, and they've got prosecutors who are willing to do that.
Do they do that in other industries, or is it specific to the security? I feel like if I went to like a pipe fitters convention or a dental equipment convention, I wouldn't have to worry that the guy over there is maybe working for the feds.
Yeah, no, it's not unique in the securities industry.
If the SEC is here, I was just kidding. I love you guys.
Chris, if we have a mole in here, we're going to point the finger at you.
Well, no, there was one, but they converted to practice.
Let's see any of the former agents I used to work with.
Yeah.
I guess that's a good thing. No, I actually had a case, a corruption case involving the Department of Motor Vehicles, where we actually we went in at night, surreptitiously entered a recording device inside the DMV, obviously with the DMV's consent. We didn't just eagerly go in there and do that. But then we wiretapped not only the computers that the DMV employees were using, but we wiretapped people's phones. And that was something that was not usual in a white-collar case. It ended up uncovering a large bribery scheme where people who were working at the DMV were giving licenses out to people who couldn't pass the tests, including commercial driver's licenses. You have people driving trucks on the road and didn't pass the commercial driving test, driving these tractor trailers and these tankers. So it is not unique in securities, but I know you're familiar with kind of the operation that they ran. But the San Diego kind of tends to be a very forethought area when it comes to criminal justice.
I'd love to, we're running out of time, and I feel like we would really make a mistake if we didn't talk about the new enforcement. I've put down about 8 changes that are here, but the one thing that I noticed is SEC never really had a cooperation regime. They didn't behave like the DOJ, but now it seems that the SEC is emulating the DOJ, and they're creating factors for referrals. There's a lot less decision-making being made at the regional level and it's being made at the commission. Could you talk a little bit about the new enforcement method?
Yeah, if you'll notice, and you'll see this as companies, is that the commission is really focused on cooperation. They want the companies to self-report. They want you to get ahead of them almost. In terms of, it's kind of typical in the DOJ area as well. When we talk about cooperation, we're talking about what has the company done to get ahead of whatever the issue is. And the SEC is now doing that as well. A lot of the SEC lawyers tend to be former AUSAs, and even on the flip side, former new AUSAs tend to be former commission lawyers. So you're going to get a little bit of that crossover in experience. But for companies, the smartest thing you can do is, if you think that there's a problem, you want to call your attorney and, start self-reporting, because you want to start preserving evidence. I watched everybody in here, everyone stares at this thing in your pocket. This is not a phone. This is a computer. It's so large that it really does hold enough data to be a computer today. And if the SEC or the DOJ get a hold of it, they get a hold of your life in your pocket. So even if you scrub it.
We discussed this in preparing for this. I brought a client who had to tender his phone to be brought down and to be researched for a securities fraud issue. But then when the FBI came back in for his cooperation discussion, for his proffer, they asked about a testosterone tablet, an Adderall tablet, and some leads he bought. It created a spider web for him, dealing with charges for all of those things outside of the white collar.
And one thing I would say here is, for the folks who are in the game every day of buying and selling stock and working on promoting your company. We had a case once where we had a client who was an issuer who got a subpoena from the SEC about a stock promotion that was being run on their company stock. And they wanted to get all of the communications between the CEO, the CFO on one hand, and the IR firm on the other hand. So for those of you who are either an IR or a CEO, that potentially could apply in something. It doesn't have to do. It turned out there was nothing to our client having any involvement in it. But I will say that there's some really embarrassing texts between the IR firm and the CEO about what they were going to be doing after one of these conferences that had to be turned over to the government. And so I say that, in Joe's right in terms of what we carry around. It's not just a computer. It's evidence in a future potential SEC. So be mindful that what you write on your phones and text or chats, even if it's Snapchat, it's a library, is what it is.
When the government shows up with a search warrant for your phone, yes, you have to give them your phone. But when they then try to trick you, here's some inside baseball, not the government anymore, so I can now tell you guys this. When they try to trick you and say, don't you want your contacts out of your phone? You're freaking out. You're thinking to yourself, yeah, I need my contacts on my phone. Okay, unlock it. We'll let you get your contacts out. Well, they've just got you to unlock the phone they probably can't get into. Because despite the fact that you think the FBI has all this technology, they're light years behind what you really think they do with the upgrades to Apple iPhones and Google Pixel phones. So don't give them your passcode. Don't open your phone. I'm sure you backed it up to the iCloud. or a server, and if you haven't, go home tonight and do that, so that you have access to it, so you're like, no, I don't need that. You can have my phone, go for it. It'll probably take them 600 million years with a breaking device to try to get into it.
And all the time that they're holding your phone, all of your people will be calling thinking you died. Something I'm dealing with it right now. The client needs his phone back because he keeps getting these calls. For sure, died.
Yeah, well, I think we have time for a couple of questions.
I was reading the change of the SEC disclosure recently and trying to understand the tokenized securities. We understand allowing tokenized securities is different to tokenize all securities. But when you read interpretations, it goes both ways. Of course, one direction is to allow more freedom. The other, tokenized securities, is to heighten the control. Which direction it is?
I would say that there is a direction towards allowing more tokenization of securities. I think this administration, this commission understood that what was happening prior under Gensler and before that was that you had regulation by enforcement, which basically meant that they wouldn't put out any rules to tell you that you guys already know what the rules are. And when, of course, the entire industry said we don't know what the rules are, they said we should. And so right now they are trying to provide a better structure so that you can go in and figure out when tokenized securities need to be registered, treated as such, and when they don't. So I think this administration is going in that direction. They certainly had a huge amount of support from the crypto industry going into it, and I think they really back it. So they are going to provide more and more clean regulations as to what type of disclosures need to go with various offerings of tokenized securities.
Thank you. One more question, you guys? Oh, sorry, Mr. Yale raised his hand first.
So my question has to do with the Genius Act and stablecoin and your opinions on the prospects for the legislation to get through, given the different perspectives of banks and the custodians and the largest custodians, certainly with the cryptocurrencies and stablecoins specifically.
I really wish Mohit had come in for this from not global finance, because he would be absolutely the person to answer that question. Yeah. I think that a lot of the difficulty with crypto-backed trading and blockchain-based trading has to do with Rule 611 and the trade through rule regarding pricing, and that the national exchanges have a national best bid offer, and it's very hard to make a market around CD and Co and DTC that creates a best price without the potentiality for trade through. So there has to be like a separate agreement between the buyer and the seller that says we don't mind not getting the best price because we have these other priorities like speed.
And you guys, very quickly from Richard Magnuson.
Working great. I have a question. I was just wondering.
I say just say here.
I assume some criminals are fairly intelligent, hardworking in their own world. Right? So I'm just curious, are there any cases of criminals in the San Diego area doing their due diligence and say, we're taking our operation somewhere else, like maybe Boca? I mean, if they think like us, except they're on the other side.
Our weather's too nice in San Diego. We don't have humidity. Of course not. No, unfortunately, San Diego has plenty of white-collar crime.
On that, you guys, thank you so much.